Considering the new disruptions created by the COVID-19 pandemic, we have received a number of requests from companies willing to file for bankruptcy, especially small and medium enterprises. Bankruptcy should be looked into as an extreme measure, as a last resort. However, an increasing number of companies seek this solution in the recent times. If you're contemplating filing for bankruptcy, our senior associate Shehab Mamdouh discusses what you need to know. What are the main reasons for declaring bankruptcy for SMEs?
Based on our experience, there are two main reasons for company to seek a bankruptcy decision before the concerned court. The first reason will be depending on the financial issues that the company facing towards their creditors, and the second reason might be caused because of the lack of operation or an operational reason, where the company loses their key persons which supporting the company in generating a lot of profit. And based on that, the company may face such a huge loss. Therefore, they have the right by the law to file for bankruptcy under the guidance of the concerned court.
When should a company file for bankruptcy?
Definitely, the companies who are seeking bankruptcy, they have to be in a bad financial situation where they cannot pay or cover their debts, and they have many claims that they feel they cannot meet at certain point financially. Therefore, we believe once the company reach that limit and they have they failed to pay their debts within 60 days from the due date, it would be better for the owners or the shareholders of the company to think about initiating bankruptcy proceedings. And with the circumstances that we are facing in the moment before the pandemic situation of the coronavirus, we believe the number of cases may rise if the situation remains the same for a long time, because when the company will not be able to pay salaries, loans if they have, cover their debts, they may face a lot of problems in the future and a lot of cases. Therefore, the safest option is to seek the help of the law, which has been provided by filing a bankruptcy.
What are the legal implications on businesses?
The legal procedures for filing for bankruptcy can be done by one of two ways. First way is when the company are in debts and they cannot pay their creditors, so they can file for the bankruptcy. Second one is the creditors may seek to file a bankruptcy against one company if they fail to pay their outstanding, as long as the outstanding is above 100,000 dirhams. We will talk about the first option, where the company seek an order from the court for a bankruptcy. The law has specified how such application should be submitted. There are specific requirements of documents to be submitted. There will be a decision, a attested decision of the shareholders to be submitted to the court. It's not an easy process. It's not a one-day process. It will take a lot of time to prepare the documents, to attest the documents, and to meet the requirements to file such an application before the court. Does that mean the company will be declared bankrupt upon filing the application before the court? This is not correct. For the company to be declared a bankruptcy, the court first has to appoint a trustee. This trustee will look into the documents of the company, the list of the creditors, the list of the debtors of the company, and has several meetings and reports to be submitted before the concerned judge before the judge declare or decide whether this company should be declared as bankrupt or not.
What happens to the company's debts and credits?
Once the trustee is appointed by the court and gather all the information about the debtors and the creditors, he will then submit his report to the concerned judge, and according to that, most of the debts will try to be covered from the assets of the money, and the debts which is with third parties to be paid to the creditors. The creditors' situations, on other hand, will be like, if the company debts cannot cover the full amount of, or the company assets and money cannot cover all the debts belongs to the creditors listed, then the money which has been gathered by the trustee will be divided among the creditors in a pro rata measures. However, there are certain debts has a priority to be covered first or to be paid first, such as money owed to the government, such as the end of service of the employees, so ethic, and all this kind of priority debts are mentioned in the law, as well as how the money will be distributed between the creditors. And once it has been declared the company is bankrupt and the money has been paid according to the court decision, then we believe the company at that time or the owners or shareholders or the managers or directors of the company will not be liable for any criminal or any civil or commercial liability.
To what extent does bankruptcy impact the owner's commercial and social security?
First part, if the court granted the bankruptcy and got all the reasons which they may consider and acknowledge to consider the company is bankrupt, there will be no any implication or any bad effect or negative effects to the owners or the investors' status, whether commercial or social. However, if the court may see that the owner of the company is trying to seek bankruptcy to avoid paying or unlawfully not to pay the creditors, this might lead to a complete different way where some criminal acts may be taken against the owner and some restrictions to be implemented against the owners and the shareholders and or the managers of the company. Therefore, we advise to be very careful when you decide for bankruptcy. You must have a very valid and solid reason which to be shown to the court that you cannot pay or meet the outstanding amounts that you face or the debts that you have in the market, or you cannot really pay the salaries or loans or rent, such things. Otherwise, you have to consider your decision before filing for a bankruptcy before any court.